The final general type of insurance that we want to focus on in the context of construction is professional liability insurance. And basically here we're talking about architects and engineers as the professionals whose insurance would cover their acts and omissions. Professional liability insurance is back to third-party insurance, kind of like CGL insurance. And the basic concept here is that if an architect or an engineer, who are professionals, right, they're licensed professionals, they're required to put their stamps on the plans and drawings that they issue for construction. Well, when they commit malpractice, when their work product falls below the standard of care, whatever that may be, that's defined by not only the case law but also the party's contract, there's likely to be a problem. Okay, and it's very important, especially from the standpoint of an owner, that the architect or engineer have sufficient professional liability insurance, because architects and engineers often don't have a huge number of assets that would be readily available to satisfy any sort of judgment against them. And so if there's a problem, usually it's going to be the architect or engineer's liability carrier, professional liability carrier, that will be defending the suit against the architect or engineer and ultimately paying out any payment to the injured party, whether by way of a judgment or settlement. Like many professional liability insurance policies, including lawyers, the architects and engineers insurance is usually written on what's known as a claims made basis. And what that means is that it covers any sort of claims that are made during the policy period, even if the act that's alleged to have been negligent or otherwise wrongful occurred prior to the issuance of the policy. And so that's as opposed to an occurrence policy that covers acts and omissions that occur during the policy period. So it's important to understand which one you've got in order to understand which policy might apply. The policy limits on these policies are usually what's referred to as wasting or eroding. So for example, if you've got an architect with a $1 million malpractice policy and the owner alleges some wrongful act on the part of the architect, and the architect's insurance company steps in to defend the claim, well, the attorney's fees that are being paid to the lawyers to defend the architect, being paid by the insurance company, eat into the policy coverage. So if it costs the insurance company $250,000 in attorney's fees to defend the architect, that eats into that $1 million policy limit, and so the most that would be available to pay any judgment that the owner might obtain would be $750,000. That would be the extent of the insurer's liability. So that's an important thing to keep in mind when determining what the policy limits should be. And the policy limits are usually set forth in the contract between the owner and the architect in the first place. Now, there are some coverage issues that are peculiar to professional liability insurance policies, particularly those written for architects and engineers. One is that economic damages, that is, economic losses, things other than losses due to personal injury or losses due to property damage, may well be covered. So, for example, if there are consequential losses that an owner suffers as a result of a defect in the architect's plans. Okay, consequential losses might be delay in completing the project. Well, if the delay is attributable to some defect in the architect's plans, for example, that's not the number, the value of that delay is not a is not somebody's personal injury, right? It's not somebody losing an arm. It's not property damage, somebody's car getting destroyed. It's an economic loss. It's the time value of the project and the delay associated with that defect in the architect's performance. Well, those kinds of damages might well be covered. They very often are covered in the architect's liability insurance. Whereas other policies, such as the CGL policy, just covers personal injuries and property damages, doesn't include economic losses usually. On the other hand, some of the coverage issues under a professional liability policy can include whether the architect is liable for some sort of breach of contract. So, for example, the contract between the owner and the architect may require the architect to perform certain tasks, such as administer the contract in the field and generally supervise the contractor's work. Well, the contractor may do poor work and the architect may not catch it, but that may not rise to the level of malpractice on the part of the architect. Okay, so there's a potential disconnect here. Professional liability insurance generally covers malpractice, but a garden variety breach of contract where the architect, for example, fails to catch some defective work that the contractors performed is simply a breach of contract. It may not rise to the level of negligence on the part of the architect. Nevertheless, the architect, in my hypothetical, has a contractual obligation to the owner to catch the defective work. The architect fails to do that, it's in breach of contract, and usually is going to be required to indemnify the owner as a result of the architect's breach. Well, whether or not that the damages associated with that garden variety breach of contract that doesn't amount to negligence, whether that those damages are recoverable under the architect's professional liability insurance depends on what the liability insurance says about contractual liabilities. Sometimes insurance policies will provide for the insurer, the architect's insurer, to pay amounts that the architect ends up owing to the owner for garden variety breaches of contract. That's a great thing if you're an owner. On the other hand, many professional liability insurance policies that architects carry cover only negligent acts by the architect or the engineer. And so it's important from a coverage standpoint to know exactly what kinds of liabilities are going to be covered by this policy that the architect or engineer is providing. And again, that is a subject that is open to negotiation in the owner-architect agreement at the beginning of the project. The owner can very easily require the architect to carry specific types of professional liability insurance that includes economic damages, consequential damages resulting from delays attributable to defects in the architect's work. The owner can also require the architect to obtain professional liability insurance that provides coverage for contractual liability, right? Just garden variety breaches of contract by the architect that don't necessarily rise to the level of malpractice on the part of the architect. As with every other kind of insurance policy, there are different exclusions that may become relevant. And again, I'm not going to go into these in detail, just understand that there are a lot of exclusions. And again, these have their own body of case law that's grown up around them, defining exactly the scope of those exclusions, in addition to whatever the policy may say about what's excluded from coverage. So professional liability insurance in the context of a construction project primarily means malpractice insurance carried by the design professional, whether that be architect or engineer. And usually that's the main source of recovery for an owner, for example, in the event that the design professional either commits malpractice or simply commits a garden variety breach of the contract.